Good evening and welcome to Legal Briefs. And what a day it was in the crypto world. We had a draft of comprehensive U.S. legislation made public, and of course the big hearing on the SEC's claim of attorney-client privilege. And I have my dirty little notes right here from the hearing, and we are going to talk about that. And there was a new attorney for the SEC making the argument today at the hearing. I didn't recognize her voice, but here is video of the SEC this morning actually making the decision as to which attorney was going to make the argument at the hearing.
It's hot potato time, but if you have it when the music stops, you're out. Get ready. Hot potato, hot potato. Hot potato, hot potato, hot potato.
Welcome back, and no, that hearing didn't go well for the SEC today. Let's just get right to it. We used to call those suicide mission hearings because you were being sent to your death, but it was actually much worse for the SEC than you may even imagine, as some major errors were made today by them. And we'll talk about why that is in a second, but first, I really need to touch base on the Lummis-Gillbrand crypto bill that was just unveiled here in the US of A. You know, it's funny having two daughters, it makes you look at things a little bit differently, but I am very proud that two women put this bill together and worked together from different sides of the aisle to get this done. Girl power! Now here's the summary that you need to know. First, the bill is still a draft, but it covers everything from taxation of crypto assets to stablecoins, brokers, and to finally which regulatory body regulates digital assets. It's very comprehensive. The legislation takes a cue from the Hinman speech and makes decentralization a key term in whether a digital asset is regulated by the SEC or by the Commodities Commission. But here's the good news. Even if a digital asset still derives benefit from the efforts of a centralized entity, kind of like the Ethereum Foundation, for example, the reporting requirements are not that horrible and only require relatively minimal disclosures twice a year. Now, it's not perfect, but it's at least something that a lot of crypto projects can at least comply with if they want to. I personally hope it passes because I'm American and I'm tired of telling projects to set up in the Cayman Islands, as much as I like visiting the islands to set things up for them. So I guess you'd say the bill is bullish for crypto in America. But I know what you want to know, because I'm reading your mind. If this bill is passed, will it end the Ripple lawsuit? And I'm sorry, but even if it somehow gets passed this year, it will not end the lawsuit because, like most legislation, the law does not apply retroactively. But it could affect an important element of the case, and that is because from the date of the legislation passes and moving forward, new sales of XRP by Ripple would fall under the new law, and I believe that Ripple would register, whether it be with the SEC or with the CFTC, either way. And this bill might allow for registered lawful sales of XRP next year, even if Ripple loses most of the lawsuit. But losing the lawsuit is not what was on your mind today if you're listening to the hearing, and allow me to set the stage briefly. The court hearing today was about, again, the infamous Hinman emails that the SEC is desperately trying not to hand over to Ripple, and they basically have already lost on the deliberative process privilege argument previously, so they have then raised the attorney-client privilege argument, arguing that the various emails from SEC attorneys about Hinman's speech were all legal advice to Hinman, and therefore those are privileged and do not have to be given to Ripple. Now, a month ago, someone much better looking than myself laid out the issues for us as follows.
The test for what is covered is simple. Attorney-client privilege covers communications, 1, between you and your lawyer, 2, that are confidential, and 3, which communications constitute legal advice. I used to work for a law firm that represented California cities, and this issue was of course important to us. And working for a government agency can cause confusion about the first part of the test. Who is the client? And that is the first thing that the SEC is going to struggle with in this motion. First off, the SEC has taken no less than 3 positions on whose opinion the speech was. The problem the SEC is going to run into is that the court has already taken a hard position that Mr. Hinman's speech was his personal opinion.
Wow, that was hot. Anyways, Tinvu was pretty much spot on with her analysis because the SEC's changing positions on who or what the clients here were is definitely a problem for them. In fact, having listened to Judge Netburn at a couple of hearings now, I was listening intently for who she would first ask a question to. Now with this judge, she normally sets a hearing when she has a specific issue she wants addressed, and her very first question and her second, third, and fourth questions were all directed at the SEC. Right out of the box, she asked the SEC, semi-quote, "Help me understand what legal advice Hinman received." Now, I've seen some comments that the SEC attorney was poor, and I disagree. She was given a hospital pass. It's not her fault. Now, here's what a hospital pass is if you don't know. Yes, this poor lawyer was left catching that pass, and I will hand it to her. She stuck to her guns no matter how incredulous the judge got with her. I mean, really, that's all she could do. She tried to argue that Hinman was receiving legal advice about how the SEC applied Howey to digital assets, and he, meaning Hinman, wanted to make sure that his speech was consistent with the SEC's position. That was her argument. But by now, we know that Judge Netburn is very sharp, and she got the SEC lawyer backed into a corner very quickly. First, the judge asked a question to establish her argument. Do you still stand by that position today that Hinman's speech was his personal opinion? Now, the SEC lawyer argued that yes, that was the court's ruling, but it didn't matter that it was his personal opinion because he was still seeking legal counsel. Which led to the coup de grace statement from the judge. If he, meaning Hinman, is seeking legal advice from SEC lawyers, then they are providing advice to the SEC, not to Hinman. And then she twisted the knife a little bit more. Quote, the SEC has distanced itself from the speech, and that is problematic for me. There must be a purpose for SEC lawyers to give legal advice. And if it is his personal opinion, then there's no purpose for the legal advice. So, this is the moment of truth in the hearing. In order to win, the SEC needs to take the bull, which the judge, by the horns, and instead, well, the SEC just kind of ran from the bull ring altogether and argues that Hinman gave the speech in his official capacity. Now, that was the moment the SEC really needed to say why the legal advice for Hinman's personal opinion speech was a legal opinion and legal advice, and they just couldn't do it. But I don't think that's really poor lawyering. That's just being on a mission impossible. It's kind of like your girlfriend comes home and you're lying in bed naked with another girl. I mean, you can try to say stuff, you can say anything you want, but you are dead in the water no matter what words come out of your mouth. But there was a big mistake made by the SEC in this hearing, and it was really an unforced fumble. It's going to come back to haunt them in the future, so pay attention to this. Remember, last year we talked about a theory of a case and why it's so important to stick with your theory in litigation. And then we talked about how it was a mistake for the SEC to change its argument on what Hinman's speech was. If it was going to make the gambit that it was Hinman's personal opinion, you have to stick with that, and here's why. Now, we know Judge Netburn has already ruled that, at least for discovery purposes, Hinman's speech was his personal opinion. So the SEC can now argue it's not relevant to anything, and that's fine. But we know that that hurts the SEC in these discovery motions, so there was a trade-off there. But the SEC attorney was trying really hard today and arguing various positions in order to try to win this motion, which is probably not really possible to even win. And so what did she end up saying? Now first, when the judge was trying to lock the SEC attorney down on what the SEC's position is, the judge asked, is the SEC taking the position now that the speech reflected the Division of Corporate Finance's position? And the SEC attorney said, yes. Now she tried to equivocate a little bit after that, but the first and the direct answer was yes. And even worse, towards the end of the hearing, when the argument had turned to policy versus legal guidance, the SEC attorney actually said this. Listen to this, quote, the purpose of the speech was to provide market guidance on how the SEC would treat digital assets. Now, I couldn't believe she said that, and still right now, I doubt that my notes are correct, because this motion was already lost in the first 5 minutes. But those two remarks by the SEC attorney, especially the second one, put the Hinman speech back into play as market guidance and puts it back into relevance. It's like the SEC is having the opposite of having their cake and eating it too. So after today, with the quote that the speech was market guidance, Hinman's speech is back in play potentially as both official guidance as to whether XRP is a security and back in play as to the fair notice defense. And that's how gambits fall apart on you. You have to be very careful what you say when you're online and when you're in court, because that stuff lives forever. And in trying to win a loser, the SEC might just have lost a winner. Thanks for watching. Oh, you know John Deaton went to court live today?
Oh, really?
Yeah, he was
So
there.
you got to meet Matt Solomon?
Yep.
Are you jealous?
No. Okay, yeah.